Bruce Lehrmann came to court seeking substantial damages and walked away with nothing.
Just had a decision from the federal court in the Bruce Lehrmann defamation case.
Mr Lehrmann raped Ms Higgins.
A TV interview, a national scandal, and a courtroom showdown that crippled the country. In 2024, Justice Michael Lee handed down one of the most important defamation rulings in modern Australian history, Lehrmann and Network 10 and Lisa Wilkinson case. Today we will unpack what actually happened, what the court decided, and what this means for Australian media, defamation law, and truth itself. Let's dive in. So here's the background. Bruce Lehrmann, a former political staffer, sued Network 10 and journalist Lisa Wilkinson over a 2021 episode of The Project. In that interview, Ms Brittany Higgins alleged she was raped inside Parliament House in 2019. Lehrmann wasn't named, but he claimed people in political cycles could easily tell the story was about him. He said it destroyed his reputation. Network 10 and Ms Wilkinson said the story was true and in the public interest. In case you are not familiar with Mr. Lehrmann, he was born in 1995 in Texas. His family relocated to New South Wales after his father passed away in his infancy. Lehrmann developed interest in politics from a young age. He became an electorate officer when he studied in ANU in 2014. He then commenced employment as a health policy advisor with the Minister for Rural Health and Sport from 2017. After that, he became a policy advisor to the Senator Linda Reynolds, then Assistant Minister for Home Affairs. There he met Ms Higgins, who was an administrative officer and junior media advisor in Senator Reynolds' office. On the morning of 15 February 2021, an article entitled "Young Staffer Brittany Higgins Says She Was Raped at Parliament House" was published. On about the same day, Network 10 broadcasted the Project program and republished it on its YouTube channel. The TV broadcast and publication on website combined attracted views of almost 1 million. Mr. Lehrmann watched the broadcast live from his then solicitor's office. On 17 August 2021, Mr. Lehrmann was charged with engaging sexual intercourse with Ms Higgins without her consent. A year later, DPP dropped the charge due to health conditions of Ms Higgins, but it turned out that Ms Higgins changed her mind due to political pressure. Mr. Lehrmann then brought proceedings against all media involved in pointing fingers at him, including ABC, News Live Media, and Network 10. So how does a judge decide who is telling the truth when two people remember one night so differently? To understand why this case matters, you need to know how Australia's defamation system works. It's one of the strictest in the world. Under Section Defamation Act 2005, someone can sue if material damages their reputation. Media companies can defend themselves by proving truth, honest opinion, or qualified privilege. But here's the kicker. Australia only introduced a public interest defense in 2021 after this broadcast. That meant Network 10 and Ms Wilkinson were judged under the old, tougher rules. So what were the arguments that each side made in this legal and moral minefield? Lehrmann's side said the story was false, reckless, and unfair, a media ambush that ruined his career before the trial. Network 10 argued that the story was true and responsibly reported, that Higgins deserved to be heard and the public had a right to know. Regardless of the parties' arguments, one fact is certain and conceded, that is, two drunk government officials went into the ministerial suite for non-work purpose at the midnight in 2019. One left before the dawn and the other naked and passed out till early in the morning, discovered by the security officer. This is a breach of workplace ministerial staff code of conduct and various security protocols. And of course, it is a disgrace and a national scandal. In this case, Justice Lee cited early defamation precedents like Robert Smith and Fairfax and Rush and Nationwide News to show how courts balanced reputation against media freedom. Now let's have a close look at the key legal issues and evidence that determine the case. There are three big legal questions dominated this trial. The first issue is about identification. Did public know the story referred to Lehrmann? By asking this question, the court needs to examine whether an ordinary sensible person could draw an inference that the publication referred to Lehrmann. Justice Lee said yes, even though he wasn't named. Enough clues pointed straight to him. There are several indicators pointed towards Lehrmann, as the publication mentioned that, firstly, he was working in Sydney and got a good job. Secondly, he was a senior male advisor to Senator Reynolds. Thirdly, he had been advising her in the home affairs portfolio. And fourthly, he attended drinks with colleagues in the defense industry on the given night. Several witnesses give evidence of gossip and rumor both before and after the broadcast, which supported this conclusion. Second legal issue is about defamation. Was the story likely to damage his reputation? Absolutely. The allegations were serious. Since then, he was known as the most hated man in Australia. And thirdly, defenses. Could Network 10 and Ms Wilkinson justify what they said? They ran the substantial truth defense pursuant to Section 25 of the Defamation Act, arguing the broadcast was true. In order to make out the defense of substantial truth, Network 10 needs to discharge their onus of proving that Mr. Lehrmann raped Ms Higgins. But the standard is much lower than that in the criminal case. In civil matter, the matter is to be proved on the balance of probabilities, and it only requires a subjective belief in a state of facts. This means Network 10 and Ms Wilkinson needs to show that when there are a range of possibilities open, the fact that Lehrmann had raped Higgins is more likely than all other hypotheses available on the evidence. In more precise words cited from the judgment, it is true in substance or not materially different from truth. Also, it is notable that when the judgment was made for this case, there were law reforms regarding sexual offense. Previously, DPP must prove beyond reasonable doubt that not only the victim did not consent to the sexual activity, but also the offender was aware that such consent was not given. The legislative change in 2021 to some extent asked the offender to prove that consent to sexual activity was communicated by words or actions. This caused many convictions against the accused, who turned out to be innocent, but could not prove that consent was ever given. In addition to the substantial truth defense, Network 10 and Lisa Wilkinson also tried qualified privilege defense under Section 30 of the Defamation Act, saying that it was reasonable journalism in the public interest. There are two components to establish this defense. Firstly, the public does have an interest or apparent interest in having information on some subject. And secondly, the cost of giving to public such information on that subject needs to be reasonable in the circumstances. In particular, the publisher was required to establish that before publication, it exercised the sufficient care to ensure that proper inquiries were made, checks were made on the accuracy of sources, the conclusions drawn followed logically, fairly, and reasonably from the information obtained. The manner and extent of publication did not exceed what was reasonable, and each imputation conveyed was relevant to the subject matter. But proving the truth of a sexual assault allegation in a civil trial is not a small task. Here's how the judge handled it. Justice Lee spent weeks sifting through testimony. He said both Brittany Higgins and Bruce Lehrmann were unreliable in parts, but one key difference stood out. He found Lehrmann lied repeatedly and was indifferent to whether or not there was consent from Ms Higgins. The judge even noted he told deliberate lies, and I would not accept anything he said except where it amounted to an admission. For example, Mr. Lehrmann lied that he did not buy any drinks for Ms Higgins at a bar named The Dock and barely talked to her. The CCTV camera recorded footage that he not only bought quite a few drinks for Ms Higgins, but also spent most of the evening with Ms Higgins. As to his character, the judge said the following, put bluntly. He was a 23-year-old male cheating on his girlfriend. Having just hooked up with a woman he found sexually attractive, he had encouraged Ms Higgins' consumption of alcohol. On the other side, Ms Higgins is also not entirely trustworthy. The court noted that she crafted a narrative accusing others of putting up roadblocks for her career development, which was considered as speculative and unfounded. She also used the victimization allegation to her advantage and suddenly became a celebrated speaker, was nominated for awards, and received invitations to make nationally televised speech. She even signed a book deal for over $300,000. It also became evident that she has been selective in retaining evidence and purposefully removed data that was not in her favor. In one of the messages she sent to her friend, she said this: "I'm cleaning out my phone ahead of the police." That being said, Ms Higgins, despite inconsistencies, was ultimately more credible. She sought counseling after the incident and sent text messages to her family and friends, suggesting a pattern of typical behavior of rape victims. The judge concluded on the balance of probabilities that Lehrmann did rape Ms Higgins in the Parliament House. At the time, Ms Higgins was too intoxicated to move, resist, or give consent. Such conclusion was based on the principle of Edwards' lies. This is the principle established in the case Edwards and the Queen, that the accused post-offense lies could be used as evidence of a consciousness of guilt. That is to say, a crime offender will consciously or unconsciously resort to lies to evade punishment after committing the crime. Conversely, if an individual is accused of rape and persistently lies in an attempt to conceal the truth, then he's indeed a criminal. The court was satisfied that at the time sexual intercourse took place, Lehrmann's state of mind was such that he was indifferent to Ms Higgins' consent. Using the judge's word, he just went ahead willy-nilly and ignored the requirement of consent. That meant the story was substantially true, and the defense under Section 25 is successful. Justice Lee was careful to separate truth from process. He said Ms Wilkinson's speech in 2021 was unwise and potentially affected the criminal trial. But in this civil case, the issue was whether the project acted reasonably in publishing the interview. The judge said no. Network 10 and Ms Wilkinson did not meet the high bar for reasonable journalism. In describing Ms Wilkinson's character, the judge said this:
"As one would expect from someone with her professional background, Ms. Wilkinson was a polished and articulate witness. Regrettably, however, these not inconsiderable skills were often deployed by her in the witness box to advocate for her views."
The judge did not think Ms. Wilkinson was going off on a frolic and irresponsibly saying something off the top of her head. She was sufficiently prudent to seek advice. It also apparent that she believed what Ms. Higgins told her. However, it is apparent that she found it an explosive political story and has speculated about an extraordinary cover-up involving Linda Reynolds, Michaelia Cash, and the Prime Minister's office. There is a lack of close scrutiny on some serious allegations. For example, the media reported that Ms. Higgins was given two options, being A, she could go home to the Gold Coast for the duration of the election campaign, but this would likely impact her ability to reapply for a job in the future. Or B, she could stay on board and go to Perth, Western Australia to help with the federal election. Ms. Wilkinson then sought legal advice, and Network 10 solicitors were given a request from her for advice along the lines of this:
"We are telling this explosive political story being an extraordinary cover-up involving Linda Reynolds, Michaelia Cash, and the PMO. We need to do everything to maintain exclusivity and publish at the same time. As Maiden, who also has the story, how do we best minimize litigation risk?"
After that advice, Ms. Wilkinson decided not to reveal the name of Mr. Lehrmann, but no proper investigation was conducted to verify the authenticity of the information received from Ms. Higgins. In particular, Ms. Higgins was not questioned as to why certain material was being provided, but some was unavailable. In this context, Ms. Higgins made a remarkable assertion that her phone might have been remotely wiped. Not only was the data provided by Ms. Higgins incomplete, but also that the limited material available to her, including a photo of a bruise after the incident, was said to be carefully selected by Ms. Higgins, who had very good understanding of laws and had a very clear mind as how to get Mr. Lehrmann convicted. The court was unimpressed that insufficient work was done to ascertain or appreciate the fact that Ms. Higgins had put a stop to the police investigation. Plus, there was questionable political motivation behind this. Justice Lee explained in this way. This was a story all about Liberal Party and a female minister in the context of Me Too movement, and he had an intention to liaise with opposition from Bencher to deploy the allegations against the government during question time. Although the Network 10 did not accept the political motivation was relevant to their assessment on credibility of the story, the court found out that they actually did understand the political implications. Ms. Wilkinson, in exchanging messages with the producer, described Ms. Higgins and her friend as two birds with broken wings who have seen the inside of Canberra and don't like what they see. Such recognition of motivation should have increased care, but instead, Network 10 chose to assist the political use of the serious charges. They deliberately picked the timing of publication as 21st February 2021 during the federal election and when the government had to answer questions in March. In a text message exchanged among Ms. Wilkinson, Mr. Sheras, and Ms. Higgins, the following things have been said.
I reckon Malcolm will talk. Julie Bishop? I don't know. How close is she to Michaelia Cash and Linda Reynolds? They're all Perth girls. I'm a great believer in people's time will come. I'm incredibly salacious time.
Is it Linda's time? Please God, let it be Linda's time.
Well, I think it might be.
The best bit is Linda Reynolds will see this story through my company because we send her media clips.
We're doing a parliamentary showcase before all this starts, so it's going to be great. We're having fun.
How a pure victim of rape would say something like this? What do you think? In addition to that, Ms. Wilkinson appeared to believe that the entire system of policing could not be operated independently when it comes to the Parliament House, and any crimes about their jobs will be covered up. Court considered that she was motivated to report the story to advance her dangerous notion. And when the government published an announcement confirming that Ms. Higgins' position would not be impacted, Ms. Wilkinson did not believe that, and allegation was still made to the effect that Ms. Higgins would lose her job. Lastly, too short notice was given to Mr. Lehrmann to react and comment. In summary, Network 10 and Mr. Wilkinson failed on qualified privilege under Section 30, as they could not justify the journalism work has been handled in a reasonable manner. Fortunately, the court found Lehrmann guilty of rape. Otherwise, the media and the journalists would very likely have lost the case. They were saved by truth, not by process. And what does it all mean for the rest of us? The case carries profound implications. For the media and journalists, it demonstrates the continuing power and danger of defending the defamation claim. Truth must be proven, not assumed. And even it is for public interest, the way media handles the entire process from initial investigation to eventual publications or broadcasting must be reasonable. For the public, it stirred national discussion about consent, workplace culture, and the accountability of powerful institutions. For individuals, it underscores that civil courts can make serious factual findings, even where criminal cases fail. Just like in this case, it's almost a mini trial on Lehrmann's conducts, but by reference to a different standard. By taking this defamation case, he did not make his reputation better. Rather, the judgment makes him look even worse. So if you are a public figure, a successful entrepreneur, or a celebrity that want to sue somebody who damages your reputation, think twice. Things can get worse if you lost the case, and all evidence is exposed to the public. Overall, Justice Lee's ruling will stand as a milestone in Australia's defamation law. It shows that the line between free speech and personal reputation is delicate. This case wasn't just about Bruce Lehrmann or Lisa Wilkinson. It was about how Australia defines truth, fairness, and accountability. It was also not a victory for media or politics, but for the rule of law. But wait, the saga continues, as Mr. Lehrmann unsurprisingly appealed. So we will keep following the decision of the full court of the federal court. Who do you think is the ultimate winners of this saga? What do you think the full federal court will decide? Let me know your comments below, and thanks for watching.